that prima facie is, it is a false report on POCSO. This will be a textbook case for me to direct initiation of malicious prosecution against the lady who has done this. That the petitioner is 19 years old and the second respondent is 21 years old. The allegation is that from the said relationship, a child is born. That on the promise of marriage, the petitioner has had such a sexual relationship with the complainant, and the child is born out of the said relationship. It is a textbook illustration of misuse.
ಅದಕ್ಕೆ ಅಷ್ಟು ಕಾನ್ಫಿಡೆಂಟ್ ಆಗಿ
You are in custody?
Please.
We'll release you now. Yes.
Your Lordship may not stay, may request my Lordship don't stay the matter.
No, let the investigation go on.
Let's-
I'll release you from custody. You participate in the investigation. No, they won't take any coercive steps against you.
There are two issues, please, my lords, which are required. Firstly, my lords, day in and day out, my lords, an accused is knocking the doors of this honorable court under 528 if there is a defense evidence. They are unable to, my lords, prevail upon the police to, my lords, secure the defense evidence. The DNA test today happened only because I came before this honorable
Correct. Ildar Akhtarilla, you would have been there only throughout.
And my lords, the prosecution would have.
And bailu sigalla.
And furthermore, my lords, here what has happened, my lords, I would only say, when an accused is taken into custody, he will project his defense.
Correct.
If the same is not, my lords, taken into consideration, and if he is put into prosecution, he may tomorrow be acquitted. But the real person who has perpetrated, my lords, he will go scot-free.
We'll have
This, my lords, have to be
we'll
done.
write something in this. Sadhik, idana investigation, you cooperate with the investigation. You are in custody, alva. The petitioner is before the court calling in question the registration of the crime in crime number 402 of 2026. The second respondent is the complainant. The complainant is said to have had a relationship with the second respondent. It must be noticed that the petitioner is 19 years old and the second respondent is 21 years old. The relationship appears to have blossomed into it being physical as well, but did not stop there. The allegation is that from the said relationship, a child is born. Therefore, the petitioner, when breached the promise of marriage, which was the relationship was said to be on the foundation of promise of marriage. When the petitioner is said to have breached the promise of marriage, the complaint emerges in crime number 402 of 2026 for the aforesaid offences. The registration of the fulcrum of the complaint was that on the promise of marriage, the petitioner has had such a sexual relationship with the complainant, and the child is born out of the said relationship. On the said score, the petitioner is taken into custody. He remains in custody even today. The bail sought at the hands of the concerned court is rejected.
No, it is still
Kelilva?
pending, please.
It is still pending consideration. The petitioner knocked at the doors of this court on the score that the cry of the petitioner, the accused, and his defense is not even taken note of by the prosecution or even the concerned court where he is seeking bail, therefore had to knock at the doors of this court. It was the emphatic submission of the counsel for the petitioner that he is 19 years old and has not indulged in any act which could become the offense under section 60 for rape or promise to marry. The twist lied in the submission. The offences did not stop at the ones punishable under section 64(2)(m) or 69. It included offences under the POCSO Act of sections 4 and 6. It is this conundrum that led this court to, it is this kernel of this conundrum that led this court to pass this order. On 31, on anything, yavattu Bharat Kumar?
3720.
On 31/7/2026, the order reads as follows. The court directed DNA sampling to be done DNA sampling to be done to demonstrate to know whether the child that is said to have been born to the second respondent complainant was the petitioner's or otherwise. If the child is born of the petitioner, the offense under the POCSO could not have been alleged. The offense under POCSO is alleged of offenses punishable under 4 and 6. And the allegation is of the birth of the child. Therefore, the DNA test was directed to be conducted. The DNA test, the report of the DNA test is placed before the court, and it clearly indicates that the petitioner is not the biological father of the child that is born to the complainant. Prima facie, the child is not born to the complainant. Therefore, the petitioner, therefore the allegation that the petitioner has had such sexual relationship with the complainant needs to be investigated into, but for the said purpose, the petitioner need not be in prison. The petitioner would have been released on the said day itself, but for the DNA report being awaited. The DNA report going against the complainant, the inevitable conclusion, albeit prima facie, is the release of the petitioner from prison. The registry is directed to communicate this order to the prison authorities to direct release of the petitioner forthwith. The release of the petitioner would not mean that he would not cooperate with the investigation. He shall cooperate with the investigation, and in the garb of investigation, the respondent state shall not take any coercive steps against the petitioner till the next date of hearing, lest the matter on 11th September for further hearing.
May I make one
We'll
submission?
write something in this.
May I make one submission? My lords may kindly call for a copy of the investigation paper still now. For the reason being, the information stated, I have done it. And who all have supported the informant at that juncture are liable for malicious prosecution.
That
or
we'll see. See, malicious prosecution will come when I quash and then do something.
And 22 of POCSO Act, please, for falsely reporting.
We'll see. That prima facie is, it is a false report on POCSO. This will be a textbook case for me to direct initiation of malicious prosecution against the lady who has done this. It is a textbook illustration of misuse.
On copy, my lords. I'm not asking for the
No,
original
Barley,
copy maker.
let the entire investigation papers conducted till that date be placed before the court.
Deeply obliged.
Yes.